special is this, Lord, that I came here for a better job, in the sense better prospect, and no financial implication, continuity of service. Some people have to retire next year. Some people will not have been appointed in 99.
Before the High Court of segregation.
Sorry, Lord.
You argued segregation before the High Court.
Yes, my Lord. And my Lord, if your Lordship sees the High Court judgment, kindly, my Lord, permit me the three options which the High Court itself notes. And page 250 in the main petition, my Lord, or even in my petition, page 215.
Yes.
Sorry, my Lord. Permit me the three options which the High Court itself notes. And page 250 in the main petition, my Lord, or even in my petition, page 215. 1 second, Lord, please. The High Court notes that there are three options before the High Court, and that your Lordship will find at page number, my Lord. Lord, of the paper book, which is paragraph number 312. PDF page 295. At the foot of the page 312.
In the main act.
Dismiss the writ petition, my Lord.
Yes.
Dismiss the writ petitions on the ground of maintainability, or explore the possibility of segregating the valid appointment from the illegal one, or set aside the selection made in the selection process in the entirety.
Yes.
So the High Court did have kept these three options, my Lord, in mind. And then, my Lord, if your Lordship see below that, first option noted above is no longer available in view of the decision rendered on the issue of maintainability. That is on the limitation part, etc., that people came to the British court after, my Lord, the expiry of the panel and 3 years after the appointments had been made.
Yes.
And then on the second option, my Lord, the consideration starts from page 314, para 314, and if the Lordship will kindly come on this aspect at page number, what they say, my Lord, in para 321 and then 323. In respect of the four categories of the selection process involved, written examination has been held. Written examination in the form of OMR sheet. Original OMR sheets have been destroyed. Mirror image of the destroyed OMR sheet was required to have been preserved. CBI had seen the server of SSC and did not find any mirror image of such OMR sheets. So SSC and authority within the meaning, etc. I'll skip that. Now kindly come to 323. See, significantly, it is a claim of the SSC that scanning of the OMR sheets had taken place at the office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely so and so, who was not authorized. This raises serious questions as to the integrity, sanctity, and validity of the entire selection process and going to the root of the system. So this is the basis for not segregating, my Lord. The second option, not opting for the second thing, that whether we can segregate. And then 260, para 330 onward, the third option is considered thereafter. So I am respectfully submitting, Lord, that I am not in any CBI list. There is nothing, no such thing against me. There are government orders. I have. At page 703 in my paper book, my lord, in my 17.6 item, we have annexed a pay protection granted by the government, and the carry forward of the service book is at page 705. 703 statement of protection, and thereafter approval of that fixation of pay and protection by a superior authority, and then the service books are from 705. We have annexed one of them because there are 367 people we have, and that's why we have put it in a chart. So it shows, my lord, memo of 2008 at serial number 11, if your lordships have 703. And then 2014, and then the current. And over the page, my lord, is the approval letter. At the top of the page says approval of fixation of pay for protection of pay in respect of in-service teachers. So we are called in-service teachers, my lord. And that protection of pay happened on 16/12/19 at the foot of page 704. And the service book of this first petitioner is at 705. So, but I am, so therefore I have started by saying we are a sui generis category, because we are not somebody who has in service candidates were allowed to give, and if a lordship were to just permit me to show page 389, which was a public notice issued by the West Bengal School Service Commission allowing us to participate. And of course, I must point out, that we have to go to the High Court for allowing us to participate, because the scheme for the centralized recruitment happened for the first time in 2016. So we went to the High Court. That High Court order is also on record, saying that yes, we should be allowed to participate. And then, the public notice came, which is at page 389, which extended the period for filing nomination, filing our application up to 7th October 2016.
Only will consider this, yes.
So therefore, I am respectfully submitting, that it should not be the same brush,
Yes.
And now we are all over age. So even if, fresh election were to take place, we as in service can't even apply. And one is to retire next year, as I pointed out, I'm very grateful. Much obliged.
Yes, Ms. Diwan.
May I be excused?
Yes, yes, ma'am.
Can I follow that order? Because I will be also representing those persons against whom statutes.
You are Mr. Pratik there? All right.
But I prepared a short note. Well, my endeavor, since I have also lost the job because of this judgment, my endeavor before your lordship shall be to show the gross incorrectness in the judgment itself.
Yes.
But first, lordship may kindly see the very basis of this judgment which is challenged before your lordship was the November's order passed by this Honorable Court. In the order, there are 7 fundamental directions which were required to be gone into and followed by the Honorable Division Bench. Lordship, kindly take the first, I have just jotted down that. But the first point was, Lordship may kindly put a difference between two situations. Usually, my lord, whenever the matter is heard by your lordships send the matter, then there is an expectation that the matter will be decided on merit. But there are only few cases when your lordships feel that not only the merit is to be decided, no matter it was pending for last 3 years, 4 years, etc., but also the point of maintainability is to be decided, then my lord, my respectful submission would be that there should not be any prejudice as long as this order stands. So the first part of the order was, though there has been detailed documents, all points, this Honorable Court felt for whatever reason that there is a necessity to first decide the maintainability of the writ petition itself. The second was to examine the admissibility of the OMR sheet images. Third was, in November 23, when all the documents, affidavits by the CBI and School Service Commissions, everyone was before your lordships, there was an observation in paragraph 8. At this stage, no such outstanding case, because Justice Gangopadhyay passed an order for termination of the large number of teachers. So this was the observation by your lordships. Fourth was, these allegations would have to be established through evidence. And I would correlate on this score how the Honorable Division Bench have completely gone incorrectly. Fifth was, this is important, to ignore the findings of the earlier Division Bench on Rule 17 plus to decide afresh. Lordship may kindly connect this with the point of maintainability. Because the situation at that point of time, before this Honorable Court was that the Honorable Justice Gangopadhyay directed the School Service Commission that you must invoke your power under Rule 17. School Service Commission is a recommending authority which is governed under a particular rule, for the time being 2016 rule. Once someone is appointed on the basis of a recommendation, as an employee, I am governed under 2018 rules, which is a separate rules altogether. A point was taken before the High Court, before the Honorable Justice Gangopadhyay, and also before the then Division Bench, that once the recommending authority recommends and thereafter an appointment is done, the recommending authority becomes functus officio. But there was a direction by the Justice Gangopadhyay to the recommending authority that you invoke Rule 19, Rule 17, by which you terminate all the ballot whoever at that point of time the court found that their appointments were illegal, invoking Rule 17. So that point, whether that would be done or not, that was required to be decided, that your lordship held. Now last one, and the next page, CBI to complete investigation and submit its report. Well, this is very important. Lordship may kindly see that after this order, this was a November 23 order. After this order, well, what is usual and what is expected is that the CBI will file a report before the Honorable High Court saying everything, whatever they have got to say. But there are 3 reports which were filed by the CBI. First report was of dated 9th of January 24. That does not contain anything of 65P, anything of scan take, anything of whatever is found to be fundamental today before your lordships. Nothing. Absolute absence. Thereafter, after 19 days, second report was filed by the CBI, 16th of January 24. Lordship may be surprised to take note, in the entire report, there is not even a single word on scan take. I have seen that on the very first day when this matter was moved, one of the basic points that was expressed by your lordship, that how there can be somebody who was not even getting the tender, that's a scan-take. So that's an important issue. So after 19 days in the report for the first time, my lord, first 9th of January, nothing, not even the 65B certificate. Despite November order, there is a requirement to prove it admissibility. 16th of January, no whisper, no word, no sentence, no document on scan-take. Last report, 5th of February 24. Now, Lordship, may kindly look at two fundamental, according to my understanding, flaw. My Lord, after the amendment of the Evidence Act of Section 59, if a particular record happens to be electronic record, the only way of that electronic record to become an evidence is 65B and 65B alone, as held by your lordships in Anwar judgment. Now, there are two sets of electronic records as per the last report of the CBI. One scan-take, one Pankaj Bansal. Lordship may kindly have a look at, my lord, I am referring to the state SLP for the convenience, page 768.